Title X Crimes Against Property. Chapter 1 Robbery in General. Article 293. Who are guilty of robbery. Any person who, with intent to gain, shall take any personal property belonging to another, by means of violence or intimidation of any person, or using force upon anything shall be guilty of robbery. Robbery is the taking of personal property belonging to another, with intent to gain, by means of violence against, or intimidation of any person or using force upon anything. Kinds. 1. Robbery with violence against or intimidation of persons. 2. Robbery by the use of force upon things. Elements, in general. A. That there be, 1. Personal property, 2. Belong to another. B. That there is, 3. Unlawful taking of that property. C. That the taking must be, 4. With intent to gain, and D. That there is, 5. Violence against or intimidation of any person, or force upon anything. Personal property be real property. Belonging to another be co-owner. It can still be committed against the present possessor, not the owner. Taking must be unlawful, not clothed with authority of law. Unlawful taking is complete, when A. As to robbery with violence or intimidation of persons from the moment the offender gains possession of the thing, even if the culprit has had no opportunity to dispose the same. B. As to robbery with force upon things, the thing must be taken out of the building. Taking as element of robbery means depriving the offended party of ownership of the thing taken with the character of permanency. Intent to gain, presumed from the unlawful taking of personal property. The taker is not taking it under claim of ownership. Absence of intent to gain will make the taking of personal property grave coercion if there is violence used. Violence or intimidation as an element of robbery must be against the person of the offended party, not upon the thing taken. It includes pushing the offended party to prevent him from recovering the seized property, grabbing and wresting or twisting of hand. Intimidation refers to all forms of intimidation, need not be threat of bodily harm, pointing of gun or knife is even sufficient. The violence or intimidation must be present before the taking of personal property is complete. Exception. But when the violence results in 1. Homicide, 2. Rape, 3. Intentional mutilation, or 4. Any of the serious physical injury penalized in PAR 1 and 2 of Art. 263. The taking of personal property is robbery complexed with any of those crimes under Art. 294. Even if the taking was already complete when the violence was used by the offender's special complex crime, by reason, or accompanied by using force upon anything. Entrance of the culprit into the house or building is necessary. Not robbery if he broke the window glass and merely introduced his hand thereto. Entrance into the building must be effected by any of the means described in Arts. 299 and 302. Distinction between effects of employment of violence against or intimidation of person and those of use of force upon things. 1. Whenever violence against or intimidation of any person is used, the taking of personal property belonging to another is always robbery. If there is no violence or intimidation, but only force upon things, the taking is robbery only if the force is used either to enter the building or to break doors, wardrobes, chests, or any other kind of locked or sealed furniture or receptacle inside the building, or to force them open outside after taking the same from the building. 2. In robbery with violence against or intimidation of any person, the value of the personal property taken is immaterial. The penalty depends, A. On the result of the violence used, as when homicide, rape, intentional mutilation, or any of the serious physical injuries resulted, or when less serious or slight physical injuries were inflicted, which are only evidence of simple violence, and B. On the existence of intimidation only. But in robbery with force upon things, committed in an inhabited house, public building, or edifice devoted to religious worship, the penalty is based, A. On the value of the property taken, and B. On whether or not the offenders carry arms, and in robbery with force upon things, committed in an uninhabited building, the penalty is based on the value of the property taken. Section 1. Robbery with violence or intimidation of persons. Article 294. Robbery with violence against or intimidation of persons, penalties. Any person guilty of robbery with the use of violence against or intimidation of any person shall suffer 1. The penalty of reclusion perpetua to death, when by reason or on occasion of the robbery, the crime of homicide shall have been committed, when the robbery shall have been accompanied by rape or intentional mutilation or arson. 2. The penalty of reclusion temporal in its medium period to reclusion perpetua when by reason or on occasion of such robbery, any of the physical injuries penalized in subdivision 1 of Article 263 shall have been inflicted. 3. The penalty of reclusion temporal, when by reason or on occasion of the robbery, any of the physical injuries penalized in subdivision 2 of the article mentioned in the next preceding paragraph, shall have been inflicted. 4. The penalty of prison mayor in its maximum period to reclusion temporal in its medium period, if the violence or intimidation employed in the commission of the robbery shall have been carried to a degree clearly unnecessary for the commission of the crime, or when the course of its execution, the offender shall have inflicted upon any person not responsible for its commission any of the physical injuries covered by subdivisions 3 and 4 of said Article 263. 5. The penalty of prison correctional in its maximum period to prison mayor in its medium period in other cases. As amended by RA 18. The crime defined in this article is a special complex crime, because there is a specific penalty already prescribed. Remember, on the occasion or by reason of the robbery special complex crime. For as long as there is proof of the direct relation or intimate connection between the robbery and killing, robbery with homicide. With homicide is generic, no matter who died, no matter how many died. But accused can be made criminally liable for homicide or robbery only. In robbery with rape, intent of robbing must precede the rape. Multiple rapes will not change the characterization of the robbery with rape. Instead, it will be taken into account to impose death. Even if rape was committed in another place, it is still robbery with rape. Even if rape was committed before the taking of personal property, for as long as the primary objective is not to rape. No robbery with attempted rape, separate crimes. Taking of personal property after the rape, rape being the primary objective, it is robbery if committed with intent to gain, absent intent to gain, unjust vexation only. When rape and homicide coexist in the commission of robbery, robbery with homicide is the crime, the rape shall be considered as aggravating only. Threats to extort money distinguished from robbery through intimidation. In robbery, the intimidation is actual and immediate, whereas in threats, the intimidation is conditional or future, that is not immediate. In robbery, the intimidation is personal, while in threats it may be through an intermediary. In threats, the intimidation may refer to the person, honor or property of the offended party or that of his family, while in robbery, the intimidation is directed only to the person of the victim. In robbery, the gain of the culprit is immediate, whereas in threats, the gain of the culprit is not immediate. It is robbery when the victim did not commit a crime and he is intimidated with arrest and/or prosecution to deprive him of his personal property. It is bribery when the victim has committed a crime and gives money or gift to avoid arrest or prosecution and the public officer accepted, thereby agreed to refrain from doing something which it was his official duty to do. Robbery with violence distinguished from grave coercion. In both crimes, there is violence used by the offender. While in robbery, there is intent to gain, such element is not present in coercion. The only distinction between these two crimes is just a matter of intention. Illustration. A lost his watch. One day, A saw B using the watch. A, recognizing the watch, asked B to give it to him because it was his property. Because B refused, A, with drawn pistol, told him that if B would not give him the watch, A would kill him. Because of fear for his life, B gave the watch to A against B's will. Is the crime committed by robbery, grave threats, or grave coercion? Answer. It is grave coercion, because B was compelled to do something against his will, whether it be right or wrong. It cannot be threats, because the crime of threats, the intimidation is not actual and immediate. It is true that there was a sort of condition made, that is, B would be killed if he would not give A the watch. But the threats, the intimidation must promise some future harm or injury. When the effect of the intimidation is immediate and the offended party is compelled thereby to do something against his will, whether it be right or wrong, the crime committed is grave coercion. It cannot be robbery, because there is no intent to gain. A believed that the watch he was taking was his own property. Robbery and bribery distinguished. It is robbery when the victim did not commit a crime and he is intimidated with arrest and or prosecution to deprive him of his personal property. It is bribery when the victim has committed a crime and gives money or gift to avoid arrest or prosecution and the public officer accepted, thereby agreed to refrain from doing something which it was his official duty to do. Article 295. Robbery with physical injuries, committed in an uninhabited place and by a band, or with the use of firearm on a street, road, or alley. If the offences mentioned in subdivisions 3, 4, and 5 of the next preceding article shall have been committed in an uninhabited place or by a band, or by attacking a moving train, streetcar, motor vehicle, or airship, or by entering the passengers' compartments in a train or, in any manner, taking the passengers thereof by surprise in the respective conveyances, or on a street, road, highway, or alley, and the intimidation is made with the use of a firearm, the offender shall be punished by the maximum period of the proper penalties. In the same cases, the penalty next higher in degree shall be imposed upon the leader of the band. Remember, the article provides for the circumstances that qualifies the crime, hence, the penalty imposable shall be on the maximum period. Art. 294. The article is applicable only when robbery is committed on a street, road, highway, or alley and other circumstances specifically mentioned. Must be alleged in the information. Why? Because aggravating circumstances not mentioned in the information, even proven during trial, it cannot be taken against the accused. It cannot be offset by generic mitigating, because it is the qualifying circumstances. What can be offset is only generic aggravating. It cannot be offset by a generic mitigating circumstance. If more than one circumstance, the rest shall be treated as generic. Note, if committed on the above mentioned, the robbery is qualified. Band, more than 3, at least 4 person. Article 296. Definition of a band and penalty incurred by the members thereof. When more than 3 armed malefactors take part in the commission of a robbery, it shall be deemed to have been committed by a band. When any of the arms used in the commission of the offense be an unlicensed firearm, the penalty to be imposed upon all the malefactors shall be the maximum of the corresponding penalty provided by law, without prejudice of the criminal liability for illegal possession of such unlicensed firearms. Any member of a band who is present at the commission of a robbery by the band, shall be punished as principal of any of the assaults committed by the band, unless it be shown that he attempted to prevent the same. Note, without prejudice of the criminal liability for illegal possession of such unlicensed firearms. Is repealed by special penal law in illegal possession of firearms. It means that if the commission of a different crime, the use of firearms, will just become special aggravating circumstances. A band. The law presumed that you are in agreement. But to be exonerated, is if your agreement is only to rob, but in the course of the robbery, example someone died. The general rule is the act of one is the act of all, presumably you also agree for the homicide. It must be shown that he attempted to prevent the killing. Because, the only agreement is to rob. Failure to prove it? Conspiracy applies. Will also be liable to homicide. Requisites for liability for the acts of the other members of the band. 1. That he was a member of the band, conspiracy inherent. 2. That he was present at the commission of the robbery by that band. 3. That the other members of the band committed an assault. 4. That he did not attempt to prevent the assault. Note: unless there is proof that he made an endeavor to prevent the assault committed by others. At least 4 armed persons must take part in the commission of robbery, band. Article 297. Attempted and frustrated robbery committed under certain circumstances. When by reason or on occasion of an attempted or frustrated robbery a homicide is committed, the person guilty of such offenses shall be punished by reclusion temporal in its maximum period to reclusion perpetua, unless the homicide committed shall deserve a higher penalty under the provisions of this code. Note: the term homicide is used in a generic sense. Principal intent is to rob. Illustration: attempted robbery with homicide. People v. Karanungan, et al. There was a demand made by Karanungan to the inmates of the house to bring out their money, which constitutes an overt act of robbery. But because of the armed resistance of the victim, and accused killed him, the killing was apparently an offshoot of the plan to carry out a robbery. Frustrated robbery with homicide. People v. Ramires, the accused agreed to rob 2 LCM boats from the Navy boat pool with the idea of selling them for profit. They disarmed the guard, and when they failed to take the boats because they could not start the motor, they killed the guard. Why? Frustrated, because they already got hold of the boat. Taking is already complete. They were just unable to leave. Remember: robbery with homicide, attempted or frustrated robbery with homicide, they are special complex crime. Art. 48 for complex crime inapplicable. But attempted or frustrated robbery with serious physical injuries, governed by Art. 48. Robbery with frustrated homicide. Refresher: Article 48, complex crime. If 2 or more grave or less grave felony or the act is unnecessary means of the other. The law said that the penalty should be imposed is the most serious crime in the maximum period. In comparison to the special complex crime, the law prescribes for the specific penalties already. Do not apply Art. 48 complex crime. Article 298. Execution of deeds by means of violence or intimidation. Any person who, with intent to defraud another, by means of violence or intimidation, shall compel him to sign, execute, or deliver any public instrument or documents, shall be held guilty of robbery and punished by the penalties respectively prescribed in this chapter. Elements: 1. That the offender has intent to defraud another. 2. That the offender compels him to sign, execute, or deliver any public instrument or document. 3. That the compulsion is by means of violence or intimidation. For as long as the public instrument or document is valid, not applicable if the document is void. Includes private or commercial document. Robbery distinguished from coercion. Illustration: when the offended party is under obligation to sign, execute, or deliver the document under the law, there is no robbery. There will be coercion if violence is used in compelling the offended party to sign or deliver the document. Thus, one who, having bought and fully paid the price of a car, compelled the seller by means of violence or intimidation to sign, execute, and deliver the corresponding deed of sale, would be guilty of grave coercion, not robbery, since there is no intent to defraud. Section 2. Robbery by the use of force upon things. Robbery by the use of force upon things is committed only when either 1. The offender entered a house or building by any of the means specified in Art. 299 or Art. 302, or 2. Even if there was no entrance by any of those means, he broke a wardrobe, chest, or any other kind of locked or closed or sealed furniture or receptacle in the house of building, or he took it away to be broken or forced open outside. 2 kinds of robbery with force upon things. A robbery in an inhabited house or public building or edifice devoted to religious worship. B. Robbery in an uninhabited or in a private building. Article 299. Robbery in an inhabited house or public building or edifice devoted to worship. Any armed person who shall commit robbery in an inhabited house or public building or edifice devoted to religious worship, shall be punished by reclusion temporal, if the value of the property taken shall exceed 50,000 pesos, and if a. The malefactors shall enter the house or building in which the robbery was committed, by any of the following means. 1. Through an opening not intended for entrance or egress. 2. By breaking any wall, roof, or floor or breaking any door or window. 3. By using false keys, picklocks or similar tools. 4. By using any fictitious name or pretending the exercise of public authority. Or if b. The robbery be committed under any of the following circumstances. 1. By the breaking of doors, wardrobes, chests, or any other kind of locked or sealed furniture or receptacle. 2. By taking such furniture or objects to be broken or forced open outside the place of the robbery. When the offenders do not carry arms, and the value of the property taken exceeds 50,000 pesos, the penalty next lower in degree shall be imposed. The same rule shall be applied when the offenders are armed, but the value of the property taken does not exceed 50,000 pesos. When said offenders do not carry arms and the value of the property taken does not exceed 50,000 pesos, they shall suffer the penalty prescribed in the two next preceding paragraphs, in its minimum period. If the robbery be committed in one of the dependencies of an inhabited house, public building, or building dedicated to religious worship, the penalties next lower in degree than those prescribed in this article shall be imposed. Robbery with force upon things under subdivision. A. Elements. 1. That the offender entered a. An inhabited place, or b. Public building, or c. Edifice devoted to religious worship. 2. That the entrance was effected by any of the following means. A. Through an opening not intended for entrance or egress. B. By breaking any wall, roof, or floor or breaking any door or window. C. By using false keys, picklocks or similar tools, or D. By using any fictitious name or pretending the exercise of public authority. 3. That once inside the building, the offender took personal property belonging to another with intent to gain. Note: inhabited house is any shelter, ship, or vessel constituting the dwelling of one or more persons even though the inhabitants thereof are temporarily absent therefrom when the robbery is committed. Public building is every building owned by the government or belonging to a private person but used or rented by the government, although temporarily unoccupied by the same. Robbery with force upon things under subdivision. B. Elements. 1. That the offender is inside a dwelling house, public building, or edifice devoted to religious worship regardless of the circumstances under which he entered it. 2. That the offender takes personal property belonging to another, with intent to gain, under any of the following circumstances. A. By the breaking of doors, wardrobes, chests, or any other kind of locked or sealed furniture or receptacle, or B. By taking such furniture or objects away to be broken or forced open outside the place of the robbery. Article 300. Robbery in an uninhabited place and by a band. The robbery mentioned in the next preceding article, if committed in an uninhabited place and by a band, shall be punished by the maximum period of the penalty provided therefor. Note: the two qualifications, uninhabited place and by a band, must concur. U.S. v. Morata, et al. Qualified robbery. Distinction between two classes of robbery as to their being qualified. Robbery with force upon things, Art. 299, in order to be qualified, must be committed in an uninhabited place and by a band, Art. 300. While robbery with violence against or intimidation of persons must be committed in an uninhabited place or by a band, Art. 295. Article 301. What is an inhabited house, public building, or building dedicated to religious worship and their dependencies? Inhabited house means any shelter, ship, or vessel constituting the dwelling of one or more persons, even though the inhabitants thereof shall temporarily be absent therefrom when the robbery is committed. All interior courts, corrals, warehouses, granaries, barns, coach houses, stables or other departments or enclosed places contiguous to the building or edifice, having an interior entrance connected therewith, and which form part of the whole, shall be deemed dependencies of an inhabited house, public building, or building dedicated to religious worship. Orchards and other lands used for cultivation or production are not included in the terms of the next preceding paragraph, even if closed, contiguous to the building and having direct connection therewith. The term public building includes every building owned by the government or belonging to a private person but used or rented by the government, although temporarily unoccupied by the same. Requisite of a dependency. The following must concur. A must be contiguous to the building. B must have an interior entrance connected therewith. C must form part of the whole. Robbery committed in the garage, it is a dependency if the three requisites are present. The robbery is not deemed committed in an inhabited house. Article 302. Robbery is an uninhabited place or in a private building. Any robbery committed in an uninhabited place or in a building other than those mentioned in the first paragraph of Article 299, if the value of the property taken exceeds 50,000 pesos, shall be punished by prison correctional in its medium and maximum periods, provided that any of the following circumstances is present. 1. If the entrance has been effected through any opening not intended for entrance or egress. 2. If any wall, roof, floor, or outside door or window has been broken. 3. If the entrance has been effected through the use of false keys, picklocks or other similar tools. 4. If any door, wardrobe, chest, or any sealed or closed furniture or receptacle has been broken. 5. If any closed or sealed receptacle, as mentioned in the preceding paragraph, has been removed even if the same to broken open elsewhere. When the value of the property takes does not exceed 50,000 pesos, the penalty next lower in degree shall be imposed. In the cases specified in Articles 294, 295, 297, 299, 300, and 302 of this code, when the property taken is mail matter or large cattle, the offender shall suffer the penalties next higher in degree than those provided in said articles. Elements. 1. That the offender entered an uninhabited place or a building which was not a dwelling house, not a public building, or not an edifice devoted to religious worship. 2. That any of the following circumstances was present. A. The entrance was effected through an opening not intended for entrance or egress. B. A wall, roof, floor, or outside door or window was broken. C. The entrance was effected through the use of false keys, picklocks or other similar tools. D. A door, wardrobe, chest, or any sealed or closed furniture or receptacle was broken, or E. A closed or sealed receptacle was removed, even if the same be broken open elsewhere. 3. That with intent to gain, the offender took therefrom personal property belonging to another. Illustration, robbery in a store, when punishable under Art. 299. When under Art. 302. 1. If the store is used as a dwelling of one or more persons, the robbery committed therein would be considered as committed in an inhabited house under Art. 299, People v. Suarez. 2. If the store was not actually occupied at the time of the robbery and was not used as a dwelling, since the owner lived in a separate house, the robbery committed therein is punished under Art. 302, People v. Silvestre. 3. If the store is located on the ground floor of the house belonging to the owner of the store, have an interior entrance connected therewith, it is a dependency of an inhabited house and the robbery committed therein is punished under the last paragraph of Art. 299. U.S. v. Tupon. Article 303. Robbery of cereals, fruits, or firewood in an uninhabited place or private building. In the cases enumerated in Articles 299 and 302, when the robbery consists in the taking of cereals, fruits, or firewood, the culprit shall suffer the penalty next lower in degree than that prescribed in said articles. Immediate and natural product of the soil. Article 304. Possession of picklocks or similar tools. Any person who shall without lawful cause have in his possession picklocks or similar tools especially adopted to the commission of the crime of robbery, shall be punished by arresto mayor in its maximum period to prison correctional in its minimum period. The same penalty shall be imposed upon any person who shall make such tools. If the offender be a locksmith, he shall suffer the penalty of prison correctional in its medium and maximum periods. Elements. 1. That the offender has in his possession picklocks or similar tools. 2. That such picklocks or similar tools are specially adopted to the commission of robbery. 3. That the offender does not have lawful cause for such possession. Mere possession is punished. If used to commit robbery, absorbed in robbery. Article 305. False keys. The term false keys shall be deemed to include 1. The tools mentioned in the next preceding articles. 2. Genuine keys stolen from the owner. 3. Any keys other than those intended by the owner for use in the lock forcibly opened by the offender. Illustration number 1. Before leaving for another province with his family, A entrusted the key of the main door of his house to B, A's neighbor. One day, B used the key in opening the door of A's house and once inside took some personal belongings of A. Is B guilty of robbery? The key which he used in opening the door was not stolen, it having been entrusted to him. It was not a picklock or similar tool, as defined in Art. 305. It was the key intended by the owner, A, for use in the lock opened by B. Illustration number 2. A proposed to B, a porter of a warehouse, to get some cases of whiskey from the warehouse, offering to pay P16 a case. A suggested to B that he should take an impression of the key of the warehouse in soap paste and have another made by a locksmith. With the key made from the impression, B was able to open the warehouse from which he took cases of whiskey. What crime is committed? Robbery with the use of the false key. A is a principal by inducement while B principal by direct participation. Chapter 2 Brigandage. Article 306. Who are brigands? Penalty. When more than 3 armed persons form a band of robbers for the purpose of committing robbery in the highway, or kidnapping persons for the purpose of extortion or to obtain ransom or for any other purpose to be attained by means of force and violence, they shall be deemed highway robbers or brigands. Brigandage is a crime committed by more than 3 armed persons who form a band of robbers for the purpose of committing robbery in the highway or kidnapping persons for the purpose of extortion or to obtain ransom, or for any other purpose to be attained by means of force and violence. Persons found guilty of this offense shall be punished by prison mayor in its medium period to reclusion temporal in its minimum period if the act or acts committed by them are not punishable by higher penalties, in which case, they shall suffer such high penalties. If any of the arms carried by any of said persons be an unlicensed firearms, it shall be presumed that said persons are highway robbers or brigands, and in case of convictions the penalty shall be imposed in the maximum period. There is brigandage when A. There be at least 4 armed persons. B. They formed a band of robbers. C. The purpose is any of the following. 1. To commit robbery in the highway, or 2. To kidnap persons for the purpose of extortion or to obtain ransom, or 3. To attain by means of force and violence or any other purpose. The main object of the law is to prevent the formation of band of robbers. Thing to prove are A. That their organization of more than 3 armed persons forming a band of robbers. B. That the purpose of the band is any of those enumerated in Art. 306. C. That they went upon the highway or roamed upon the country for that purpose. D. That the accused is a member of such band. Previous activities considered in determining existence of brigandage. Brigandage v. Robbery in band. Both brigandage and robbery in band require that the offenders form a band of robbers. In brigandage, the purpose of the offenders is any of the following: 1. To commit robbery in the highway, or 2. To kidnap persons for the purpose of extortion or to obtain ransom, or 3. For any other purpose to be attained by means of force and violence. In robbery in band, the purpose of the offenders is only to commit robbery, not necessary in the highway. If the agreement among more than 3 armed men was to commit only a particular robbery, the offense is not brigandage, but only robbery in band. In brigandage, the mere formation of a band for any of the purposes mentioned in the law is sufficient, as it would not be necessary to show that the band actually committed robbery in the highway, etc. In robbery in band, it is necessary to prove that the band actually committed robbery, as a mere conspiracy to committed robbery is not punishable. Article 307. Aiding and abetting a band of brigands. Any person knowingly and in any manner aiding, abetting, or protecting a band of brigands as described in the next preceding article, or giving them information of the movements of the police or other peace officers of the government, when the latter are acting in aid of the government, or acquiring or receiving the property taken by such brigands shall be punished by prison correctional in its medium period to prison mayor in its minimum period. It shall be presumed that the person performing any of the acts provided in this article has performed them knowingly, unless the contrary is proven. Elements. 1. That there is a band of brigands. 2. That the offender knows the band to be of brigands. 3. That the offender does any of the following acts. A. He in any manner aids, abets or protects such band of brigands, or B. He gives them information of the movements of the police or other peace officers of the government, or C. He acquires or receives the property taken by such brigands. PD 532 amends Art. 306 in such a manner of increasing the penalty, and it defines Phil Highway. Chapter 3. Theft. Article 308. Who are liable for theft. Theft is committed by any person who, with intent to gain but without violence against or intimidation of persons nor force upon things, shall take personal property of another without the latter's consent. Theft is committed by any person who, with intent to gain but without violence against or intimidation of persons nor force upon things, shall take personal property of another without the latter's consent. Theft is likewise committed by 1. Any person who, having found lost property, shall fail to deliver the same to the local authorities or to its owner. 2. Any person who, after having maliciously damaged the property of another, shall remove or make use of the fruits or object of the damage caused by him, and 3. Any person who shall enter an enclosed estate or a field where trespass is forbidden or which belongs to another and without the consent of its owner, shall hunt or fish upon the same or shall gather cereals, or other forest or farm products. Elements. 1. That there be taking of personal property. 2. That said property belongs to another. 3. That the taking be done with intent to gain. 4. That the taking be done without the consent of the owner. 5. That the taking be accomplished without the use of violence against or intimidation of persons or force upon things. When is taking complete so that theft is consummated? In the case of People v. Naval, the taking is considered complete when the offender is able to place the thing taken under its control and in such a situation as he could dispose of it at once. In other cases, it was held that asportation is complete from the moment the offender had full possession of the thing, even if he did not have an opportunity to dispose of the same. Illustration. 1. While the accused was behind the offended party, in the midst of a crowd in front of the public market, he abstracted from the pocket of the trousers of the offended party a pocketbook containing P12. The accused already had the pocketbook when the offended party perceived the theft, caught hold of the accused's shirt front, at the same time shouting for a policeman. After a struggle he recovered his pocketbook and let go of the accused, who was caught by a policeman. 2. The defendant took from a chest a sum of money belonging to the offended party and then placed it over the cover of the chest. At the moment, he was caught by 2 guards. 3. Accused arrested for shoplifting. Distinguished. 1. A truck loaded with stolen boxes of rifles was on the way out of the checkpoint in South Harbor surrounded by a tall fence when an MP guard discovered the boxes on the truck. It was held that the crime committed was frustrated theft, because of the timely discovery of the boxes on the truck before it could pass out of the checkpoint. People v. Dino. 2. In the supply depot in Quezon City, the accused removed from the pile 9 pieces of hospital linen and took them to their truck, where they were found by a corporal of the MP Guards when they tried to pass through the checkpoint. It was held that the crime committed was consummated theft. People v. Espiritu. There is no crime of frustrated theft. Unlawful taking or apoderamento is deemed complete from the moment the offender gains possession of the thing, even as he has no opportunity to dispose of the same. Taking and theft do not need to be permanent in character. People v. Fernandez, et al. Further illustration to distinguish theft from robbery. Thus, if A entered the house of B through an open door and once inside he removed by force toilet fixtures and carried them away, A is liable for theft in spite of the use of force upon things, because the force was not employed to enter the house. The only case where the taking of personal property with force upon things is robbery, even if the culprit did not enter the house or building with force upon things, is when a furniture, chest, or other locked or sealed receptacle is broken in the house or building or taken therefrom and broken outside. Elements of hunting, fishing, or gathering fruits, etc., in enclosed estate. 1. That there is an enclosed estate or a field where trespass is forbidden or which belongs to another. 2. That the offender enters the same. 3. That the offender hunts or fishes upon the same or gathers fruits, cereals, or other forest or farm products in the estate or field, and 4. That the hunting or fishing or gathering of products is without the consent of the owner. Fish should not be in the fish pond. Article 309. Penalties. Any person guilty of theft shall be punished by 1. The penalty of prison mayor in its minimum and medium periods, if the value of the thing stolen is more than 1,200,000 pesos but does not exceed 2,200,000 pesos, but if the value of the thing stolen exceeds the latter amount, the penalty shall be the maximum period of the one prescribed in this paragraph, and 1 year for each additional 1,000,000 pesos, but the total of the penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed and for the purpose of the other provisions of this code, the penalty shall be termed prison mayor or reclusion temporal, as the case may be. 2. The penalty of prison correctional in its medium and maximum periods, if the value of the thing stolen is more than 600,000 pesos but does not exceed 1,200,000 pesos. 3. The penalty of prison correctional in its minimum and medium periods, if the value of the property stolen is more than 20,000 pesos but does not exceed 600,000 pesos. 4. Arresto mayor in its medium period to prison correctional in its minimum period, if the value of the property stolen is over 5,000 pesos but does not exceed 20,000 pesos. 5. Arresto mayor to its full extent, if such value is over 500 pesos but does not exceed 5,000 pesos. 6. Arresto mayor in its minimum and medium periods, if such value does not exceed 500 pesos. 7. Arresto menor or a fine not exceeding 20,000 pesos, if the theft is committed under the circumstances enumerated in paragraph 3 of the next preceding article and the value of the thing stolen does not exceed 500 pesos. If such value exceeds said amount, the provision of any of the 5 preceding subdivisions shall be made applicable. 8. Arresto menor in its minimum period or a fine not exceeding 5,000 pesos, when the value of the thing stolen is not over 500 pesos, and the offender shall have acted under the impulse of hunger, poverty, or the difficulty of earning a livelihood for the support of himself or his family. Article 310. Qualified theft. The crime of theft shall be punished by the penalties next higher by 2 degrees than those respectively specified in the next preceding article, if committed by a domestic servant, or with grave abuse of confidence, or if the property stolen is motor vehicle, mail matter, or large cattle, or consists of coconuts taken from the premises of the plantation or fish taken from a fish pond or fishery, or if property is taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident, or civil disturbance. As amended by RA 120 and BPBLG 71. May 1, 1980. Theft is qualified, when 1. If the theft is committed by a domestic servant. 2. If the theft is committed grave abuse of confidence. 3. If the property stolen is a motor vehicle, b. mail matter, or c. large cattle. 4. If the property stolen consists in coconut taken from the premises of a plantation. 5. If the property stolen is fish taken from a fish pond or fishery. 6. If the property taken on the occasion of fire, earthquake, typhoon, volcanic eruption, or any other calamity, vehicular accident or civil disturbance. Theft by domestic servant is always qualified. In abuse of confidence, the same must be grave, characterized by access on the subject of theft or was in her possession just like a bank teller. The confidence gravely abused must be that existing between the offended party and the offender. Article 311. Theft of the property of the National Library and National Museum. If the property stolen be any property of the National Library or the National Museum, the penalty shall be arresto mayor or a fine ranging from 40,000 to 100,000 pesos, or both, unless a higher penalty should be provided under other provisions of this code, in which case, the offender shall be punished by such higher penalty. Chapter 4 Usurpation. Article 312. Occupation of real property or usurpation of real rights in property. Any person who, by means of violence against or intimidation of persons, shall take possession of any real property or shall usurp any real rights in property belonging to another, in addition to the penalty incurred for the acts of violence executed by him, shall be punished by a fine from 50 to 100% of the gain which he shall have obtained, but not less than 15,000 pesos. If the value of the gain cannot be ascertained, a fine of from 40,000 to 100,000 pesos shall be imposed. Acts punishable under Art. 312. 1. By taking possession of any real property belonging to another by means of violence against or intimidation of persons. 2. By usurping any real rights in property belonging to another by means of violence against or intimidation of persons. Elements. A. That the offender takes possession of any real property or usurps any real rights in property. B. That the real property or real rights belongs to another. C. That violence against or intimidation of persons is used by the offender in occupying real property or usurping real rights in property. D. That there is intent to gain. Illustration. The accused, who had lost the case in Cadas trial proceeding, took possession of the land adjudicated in favor of the offended party and harvested the polity, by means of threats and intimidation. Held, guilty of usurpation of real right. People v. Calleja. Violence and intimidation must be the means used in occupying real property or usurping real right belonging to another. Not applicable if accused is already in possession and uses violence or intimidation to retain possession. People v. Dimacutuc. In addition to the penalty incurred for the acts of violence or intimidation executed by him. Distinguished from theft or robbery. A. While there is taking or asportation in theft or robbery, there is occupation or usurpation in this crime. B. In theft or robbery, personal property is taken. In this crime, there is real property or real right involved. C. In both crimes, there is intent to gain. Article 313. Altering boundaries or landmarks. Any person who shall alter the boundary marks or monuments of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same, shall be punished by arresto menor or a fine not exceeding 20,000 pesos, or both. Elements. 1. That there be boundary marks or monuments of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same. 2. That the offender alters said boundary marks. Intent to gain is not necessary. Alter has a general and indefinite meaning, may include destruction of stone monument, taking it to another place or removing a fence. Chapter 5, Culpable Insolvency. Article 314. Fraudulent insolvency. Any person who shall abscond with his property to the prejudice of his creditors, shall suffer the penalty of prison mayor, if he be a merchant, and the penalty of prison correctional in its maximum period to prison mayor in its medium period, if he be not a merchant. Being a merchant or not determines the penalty to be imposed. Elements. 1. That the offender is a debtor, that is, he has obligation due and payable. 2. That he absconds with his property. 3. That there be prejudice to his creditors. Note: actual prejudice is required. Perceived prejudice is not sufficient. Illustration. Defendant was a merchant of good standing, but he became indebted to several merchants in Cebu. Judgment was rendered against him and execution issued. He owned several parcels of real property which he transferred to another place beyond the reach of his creditors. The considerations in the deed of sale were all fictitious. Held: fraudulent insolvency made in fraud of creditors is committed. People v. Tandion. If creditor has other available properties, the article does not apply. Chapter 6, Swindling and Other Deceits. Elements of estafa in general. 1. That the accused defrauded another, a. by abuse of confidence, or b. by means of deceit, and 2. That damage or prejudice capable of pecuniary estimation is caused to the offended party or third person. The first element covers the 3 different ways of committing estafa under Art. 315. A. With unfaithfulness or abuse of confidence. B. By means of false pretenses or fraudulent acts, or C. Through fraudulent means. Article 315. Swindling, estafa. Any person who shall defraud another by any of the means mentioned herein below shall be punished by: first, the penalty of prison correctional in its maximum period to prison mayor in its minimum period, if the amount of the fraud is over 2,400,000 pesos but does not exceed 4,400,000 pesos, and if such amount exceeds the latter sum, the penalty provided in this paragraph shall be imposed in its maximum period, adding 1 year for each additional 2 million pesos, but the total penalty which may be imposed shall not exceed 20 years. In such cases, and in connection with the accessory penalties which may be imposed under the provisions of this code, the penalty shall be termed prison mayor or reclusion temporal, as the case may be. Second, the penalty of prison correctional in its minimum and medium periods, if the amount of the fraud is over 1,200,000 pesos but does not exceed 2,400,000 pesos. Third, the penalty of arresto mayor in its maximum period to prison correctional in its minimum period if such amount is over 40,000 pesos but does not exceed 1,200,000 pesos. Fourth, by arresto mayor in its medium and maximum periods, if such amount does not exceed 40,000 pesos, provided that in the 4 cases mentioned, the fraud be committed by any of the following means. 1. With unfaithfulness or abuse of confidence, namely: a. By altering the substance, quantity, or quality or anything of value which the offender shall deliver by virtue of an obligation to do so, even though such obligation be based on an immoral or illegal consideration. Illustration. Altering the substance. A. Agreed to deliver to B 5 grams of shabu, and after receipt of the payment, A delivered to B tawas instead. Elements of estafa with unfaithfulness. 1. That the offender has an onerous obligation to deliver something of value. 2. That he alters its substance, quantity, or quality. 3. That damage or prejudice is caused to another. Altering the quantity. A. Agreed to deliver 300 sacks of first-class rice to B, however, A delivered to B only 200 sacks of rice instead. Altering the quality. A. Agreed to deliver 300 sacks of first-class rice to B, however, A delivered to B third-class sacks of rice instead. B. By misappropriating or converting, to the prejudice of another, money, goods, or any other personal property received by the offender in trust or on commission, or for administration, or under any other obligation involving the duty to make delivery of or to return the same, even though such obligation be totally or partially guaranteed by a bond, or by denying having received such money, goods, or other property. money, goods, or other personal property must be received by the offender. Offender's receipt must be under certain kinds of transaction transferring juridical possession to him. Juridical possession means a possession which gives the transferee a right over the thing which the transferee may set up even against the owner. Illustration. The thing was received in trust. The accused were tenants of the offended party. They received from the sale of abaca harvested by them a sum of money including one half which belonged to the offended party under their tenancy agreement. The accused were under obligation to deliver to the offended party his share of the proceeds of the sale. Instead of turning it over to him, accused appropriated it for his own use. People v. Carulaz. The thing was received on commission. A received a diamond ring from B for sale with obligation to remit the proceeds if sold and / or return the same if not sold a month after. A failed to sell the diamond ring nor she returned it to B despite demands. Under a contract of lease, the accused hired the truck of the offended party until 5 o'clock in the afternoon of the same day for the sum of P800. The truck was never returned as it had been sold to a third person. Compare. Estafa by misappropriation. The appellant was the treasurer of the Manila Railroad Company, MRC. He took the sum of P8,330 out of the funds of Manila Railroad Company, replacing it with his personal check of the same amount, drawn on the Philippine National Bank. He directed the cashier to hold the check and not to deposit it on the current bank account of MRC until the end of the month. The appellant used the amount for his personal and private purposes. Upon audit of the insular auditor, the latter found the same as part of the cash on hand of MRC. Upon inquiry, said check is not fully funded, though appellant deposited sums of money sufficient to cover the check. Held, he is guilty of estafa even if he had no intention to permanently misappropriate the funds for himself. Thus, when the contract under which the thing is received is one of purchase and sale, even if the price is not paid, ownership is transferred to the buyer upon the delivery of the thing to him. If the buyer sold the thing and did not pay the price to the original owner, there is only civil liability. Note, there is transfer of ownership. Illustration. The accused received a radio from the complainant to keep the same for trial for 5 days, at the termination of which he bound himself to either return it or, if he desired to retain it, pay the initial sum of P90, and the balance in installments. The accused never returned the radio to the complainant. Held, that as the accused chose to retain the radio set, the transaction, theretofore indefinite, became automatically a sale. There is no estafa even if for 8 months the accused deliberately avoided paying anything at all. Sisson v. People. In a contract for the sale of property on trial basis, retention by the buyer of the property object of the sale without giving notice of rejection to the owner after the expiration of the agreed trial period, passes ownership of the property to him. Estafa by conversion. The accused received the ring to sell under the condition that she was to return it the following day if not sold, and without authority to give to a third person in payment of the cloth that said subagent had obtained from said third person. Held, granting that the accused may not have had the intention of defrauding the owner of the ring when she received it, the accused certainly committed abuse of confidence when she violated the above condition. The filing of criminal action by the agent against the subagent is no defense. In giving the ring to a subagent, the accused assumed the right to dispose of it as if it were hers, thereby committing conversion and a clear breach of trust. People v. Flores. Estafa by denying having received the thing. Thus, if A borrowed a ring from B to be used by the former on a certain occasion and later, when B asked A to return it, the latter denied having received it, A is guilty of estafa. In the case of US v. Yap Tianzhong, the accused who denied having received a box of cinnamon delivered to him by mistake was convicted of estafa. Generally, in estafa, the offender receives the thing, he does not take the thing without the consent of the owner. Estafa with abuse of confidence v. malversation. 1. In both crimes, the offenders are entrusted with funds or property. 2. Both are continuing offenses. 3. In estafa, the funds or property are always private, while in malversation, they are usually public funds or property. 4. In estafa, the offender is a private individual or even a public officer who is not accountable for public funds or property, while in malversation, the offender who is usually a public officer is accountable for public funds or property. 5. In estafa, with abuse of confidence, the crime is committed by misappropriating, converting, or denying having received money, goods or other personal property, while in malversation, the crime is committed by appropriating, taking, or misappropriating or consenting or through abandonment or negligence, permitting any other person to take the public funds or property. Illustration: where the accused policeman asked for the pistol of the offended party, on the pretext that it should be delivered to the Detective Bureau for examination and that it would be returned in 3 days, and once in possession of the pistol, he sold it. It was held that the policeman was guilty of estafa, People v. Bautista. But if the policeman, having custody of a firearm seized from a person without permit to possess it, is guilty of malversation for the disappearance of said firearm. Misappropriation of firearm received by a policeman is estafa. If it is not involved in the commission of a crime, it is malversation. If it is involved in the commission of a crime. Illustration: where the accused policeman asked for the pistol of the offended party, on the pretext that it should be delivered to the Detective Bureau for examination and that it would be returned in 3 days, and once in possession of the pistol, he sold it. It was held that the policeman was guilty of estafa, People v. Bautista. But if the policeman, having custody of a firearm seized from a person without permit to possess it, is guilty of malversation for the disappearance of said firearm. Misappropriation of firearm received by a policeman is estafa. If it is not involved in the commission of a crime, it is malversation. If it is involved in the commission of a crime. Elements of estafa by taking undue advantage of the signature in blank. 1. That the paper with the signature of the offended party be in blank. 2. That the offended party should have delivered it to the offender. 3. That above the signature of the offended party a document is written by the offender without authority to do so. 4. That the document so written creates a liability of, or causes damage to, the offended party or any third person. C. By taking undue advantage of the signature of the offended party in blank, and by writing any document above such signature in blank, to the prejudice of the offended party or of any third person. Illustration: a left to be a blank paper with a signature with a request to make a receipt for future payment to be made by a debtor, but instead, B wrote thereon a veil for some merchandise in the name of A. B made use of the merchandise for personal benefit. The veil so written created a liability against A and would cause damage to him, because the owner of the merchandise could make a pay for the value of the merchandise delivered to B by reason of the veil. The paper with the signature in blank must be delivered by the offended party to the offender. 2. By means of any of the following false pretenses or fraudulent acts executed prior to or simultaneously with the commission of the fraud. Elements of estafa by means of deceit. 1. That there must be a false pretense, fraudulent act, or fraudulent means. 2. That such false pretenses, fraudulent act, or fraudulent means must be made or executed prior to or simultaneously with the commission of the fraud. 3. That the offended party must have relied on the false pretense, fraudulent act, or fraudulent means, that is, he was induced to part with his money or property because of the false pretense, fraudulent act, or fraudulent means. 4. That as a result thereof, the offended party suffered damage. There is no deceit if the complainant was aware of the fictitious nature of the pretense. Ways of committing estafa under this provision. A. By using fictitious name, or falsely pretending to possess power, influence, qualifications, property, credit, agency, business, or imaginary transactions, or by means of other similar deceits. Illustrations. Estafa by using fictitious name. There is use of fictitious name when a person uses a name other than his real name. Thus, when a person found a pawn shop ticket in the name of another and, using the name of that other person, redeemed the jewelry mentioned therein, he committed estafa by using fictitious name, People v. Yose. Estafa by falsely pretending to possess power. A wanted to get a Caraballo, valued at P77 from B, an ignorant Igorot. By means of a piece of paper which A delivered to B, A induced the latter to accept it as payment of his Caraballo upon A's representation and guarantee that it was an instrument which would make a coin paper and silver money after the lapse of 7 Fridays, provided that B would offer prayers for the success of the enterprise. By reason of that misrepresentation, B delivered the Caraballo and accepted the worthless piece of paper in payment thereof. Estafa by falsely pretending to possess influence. If the accused represented to the offended party, a Chinaman, that he had influence in Malacanang, the BI, and the DFA, when in truth and in fact he had no influence in any of said offices and said representation was made by him for the purpose of inducing the offended party, who was interested in the entry of his family for permanent residence in the Philippines, to give him money, and the offended party gave him the amount asked for his alleged services, which he later spent for his own benefit. The accused is guilty of estafa. Estafa by falsely pretending to possess qualification. The offended party had a civil case in a justice of the peace court involving his real estate. The accused, by means of false representation that he was qualified in law to represent the offended party in that civil case, succeeded in obtaining from the latter the title deeds of his lands. The accused later refused to deliver them on demand by the owner. Estafa by falsely pretending to possess property, money. A ordered certain building materials from B on the pretense that he was building a house and that he had sufficient funds to pay in cash the value of said materials on completion of their delivery, when in truth and in fact, he had no money. B could not recover the material because A disposed of them, People v. Santos. Estafa by falsely pretending to possess credit. In a case where the accused, by stating and representing themselves to the employees of Sun Photo Supply that they were merchants with credit, business, and means with which to pay for 10 dozen rolls, Kodak film number 116, valued at P72, succeeded in inducing the employees of Sun Photo Supply to give and deliver, as in fact the latter gave and delivered to said accused, the goods and merchandise on credit, the accused knowing that their statements and representations that they had credit, business, and means were false, and disappeared and absconded themselves with said goods and merchandise, it was held that they were guilty of estafa. People v. Calayan, et al. Estafa by falsely pretending to possess agency. In a case where the accused falsely pretended to the depositary of certain goods that he was sent by the depositor of the goods to get them, and succeeded by means of such false pretenses in obtaining the goods which he converted to his own use, it was held that the accused was guilty of estafa. The accused falsely pretended to possess the agency of the depositor, People v. Contreras. Estafa by falsely pretending to possess business. The accused, pretending to be engaged in the business of buying and selling hogs, represented to the offended party that they, accused, had purchased some hogs in Pampanga but could not secure delivery because they were short of funds in the sum of P285, and that the hogs could be sold in Manila at a profit. Because of the representation, the offended party gave money. The accused in reality had no such business and spent the money, People v. Acuna, et al. For deceits not covered by any of those specifically mentioned in subdivision 2, PAR, A, but similar to any of them, may give rise to estafa under that phrase by means of other similar deceits. The offender must be able to obtain something from the offended party because of the false pretense, that is, without which the offended party would not have parted with his money or property. Estafa through falsification. Any person who falsifies, counterfeits, or imitates the signatures of the officials appearing in the traffic police sticker, a sort of road or bridge pass, and sells it, is liable for estafa through falsification of public or official document. People v. Assistio. Complex crime, the falsification being a necessary means of committing estafa. Estafa by b. By altering the quality, fineness, or weight of anything pertaining to his art or business. The estafa by altering the quality, fineness, or weight of anything pertaining to his art or business may be illustrated in the case of a jeweler who, for instance, defrauded a person who had delivered to him a diamond and piece of gold to be made into ring by changing the stone with one of lower quality. C. By pretending to have bribed any government employee, without prejudice to the action for calumny which the offended party may deem proper to bring against the offender. In this case, the offender shall be punished by the maximum period of the penalty. This is committed by any person who would ask money from another for the alleged purpose of bribing a government employee, when in truth and in fact the offender intended to convert the money to his own personal use and benefit. Compare. Thus, a person who obtains money from another by falsely pretending that with that money he will bribe the doctor in charge of the physical examination of the offended party so as to declare him unfit for compulsory service in the army, is guilty of estafa under this paragraph. But if he really gives the money to the doctor, the crime is corruption of public officer. Estafa by means of fraudulent acts. The acts must be fraudulent, that is, the acts must be characterized by, or founded on, deceit, trick or cheat. Note that while in false pretenses the deceit consists in the use of deceitful words, in fraudulent acts the deceit consists principally in deceitful acts. Estafa by d. By post-dating a check, or issuing a check in payment of an obligation when the offender had no funds in the bank, or his funds deposited therein were not sufficient to cover the amount of the check. The failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank and or the payee or holder that said check has been dishonored for lack or insufficiency of funds shall be prima facie evidence of deceit constituting false pretense or fraudulent act. As amended by RA 4885, approved June 17, 1967. Estafa by post-dating a check or issuing a check in payment of an obligation. Elements. 1. That the offender post-dated a check, or issued a check in payment of an obligation. 2. That such post-dating or issuing a check was done when the offender had no funds in the bank, or his funds deposited therein were not sufficient to cover the amount of the check. The check issued must be genuine and not falsified. The check must be post-dated or issued in payment of an obligation contracted at the time of the issuance and delivery of the check. Note: the accused must be able to obtain something from the offended party by means of the check he issues and delivers. When check is issued in substitution of a promissory note, it is in payment of pre-existing obligation, no estafa. When the post-dated checks are issued and intended by the parties only as a promissory note, there is no estafa even if there are no sufficient funds in the bank to cover the name. Check readies counting, no estafa through post-dating a check. Check if issued as a guarantee, no estafa. Prima facie evidence of deceit, the failure of the drawer of the check to deposit the amount necessary to cover his check within 3 days from receipt of notice from the bank and or the payee or holder that said check has been dishonored for lack or insufficiency of funds shall be prima facie evidence of deceit constituting false pretense or fraudulent act. The person who uses the check may also be liable, one who got hold of a check issued to another, knowing that the drawer had no sufficient funds in the bank and used the same in the purchase of goods, is guilty of estafa, people vis leta. Any person who shall defraud another by means of false pretenses or fraudulent acts as defined in paragraph 2, d, hereof shall be punished by: first, the penalty of reclusion temporal in its maximum period if the amount of fraud is over P4,400,000 but does not exceed P8,800,000. If the amount exceeds the latter, the penalty shall be reclusion perpetua. Second, the penalty of reclusion temporal in its minimum and medium periods, if the amount of the fraud is over P2,400,000 but does not exceed P4,400,000. Third, the penalty of prison mayor in its maximum period, if the amount of the fraud is over P1,200,000 but does not exceed P2,400,000. Fourth, the penalty of prison mayor in its medium period, if such amount is over P40,000 but does not exceed P1,200,000. Fifth, by prison mayor in its minimum period if such amount does not exceed P40,000. 3. Through any of the following fraudulent means. A. By inducing another, by means of deceit, to sign any document. B. By resorting to some fraudulent practice to ensure success in a gambling game. C. By removing, concealing, or destroying, in whole or in part, any court record, office files, document, or any other papers. Estafa by inducing another to sign any document. Elements. 1. That the offender induced the offended party to sign a document. 2. That deceit be employed to make him sign the document. 3. That the offended party personally signed the document. 4. That prejudice be caused. Illustration number 1. Estafa by inducing another to sign document. While a person was detained and anxious to obtain liberty, the accused induced him through fraud and deceit to sign what was represented to him to be a mortgage deed of his land for the purpose of securing the payment of attorney's fees, whereas the instrument was really an absolute conveyance of the property. U.S. v. Berry. Illustration number 2. Estafa by resorting to some fraudulent practice to ensure success in gambling. Some moments before the cockfight, the accused removed the gaff from one of the gamecocks and replaced it in an entirely different manner from that in which it was before, without the knowledge and consent of its owner. In that manner the gamecock was fixed, it could not inflict mortal wounds on and kill its opponent. As a result, the owner lost his bet. U.S. v. Na. Estafa by removing, concealing, or destroying documents, elements. 1. That there be court record, office files, documents, or any other papers. 2. That the offender removed, concealed, or destroyed any of them. 3. That the offender had intent to defraud another. Note, if no intent to defraud, the act of destroying court record will be malicious mischief. Illustration number 3. Estafa by concealing document or any other paper. A person who concealed a document evidencing a deposit of P2,600 which came into his possession when he offered to collect the deposit, is guilty of estafa. It is not necessary to inquire whether as a matter of fact the complainant has ever succeeded in collecting the deposit or not. The extent of the fraud in this case should be graded according to the amount which the document represents. Estafa by destroying document. Destruction of promissory note given back to the maker to be replaced with a new one to renew the loan, without making a new promissory note is estafa because destroying the old one, the offended party was dispossessed of the evidence of a debt. U.S. v. Kileko. Estafa by removing, concealing, or destroying documents v. Infidelity in the custody of documents, Art. 226. 1. The crime of infidelity in the custody of documents, as defined in Art. 226, and this kind of estafa are similar in that manner of committing the offenses is the same. 2. But while under Art. 226, the offender is a public officer who is officially entrusted with the document, in this kind of estafa, the offender is a private individual or even a public officer who is not officially entrusted with the documents. 3. In estafa, there is intent to defraud. This element is not required in infidelity in the custody of documents. Article 316. Other forms of swindling. The penalty of arresto mayor in its minimum and medium period and a fine of not less than the value of the damage caused and not more than 3 times such value, shall be imposed upon 1. Any person who, pretending to be owner of any real property, shall convey, sell, encumber or mortgage the same. 2. Any person, who, knowing that real property is encumbered, shall dispose of the same, although such encumbrance be not recorded. 3. The owner of any personal property who shall wrongfully take it from its lawful possessor, to the prejudice of the latter or any third person. 4. Any person who, to the prejudice of another, shall execute any fictitious contract. 5. Any person who shall accept any compensation given him under the belief that it was in payment of services rendered or labor performed by him, when in fact he did not actually perform such services or labor. 6. Any person who, while being a surety in a bond given in a criminal or civil action, without express authority from the court or before the cancellation of his bond or before being relieved from the obligation contracted by him, shall sell, mortgage, or, in any other manner, encumber the real property or properties with which he guaranteed the fulfillment of such obligation. Par.1. By conveying, selling, encumbering, or mortgaging any real property, pretending to be the owner of the same. Elements. 1. That the thing be immovable, such as a parcel of land or a building. 2. That the offender who is not owner of said property should represent that he is the owner thereof. 3. That the offender should have executed an act of ownership, selling, leasing, encumbering, or mortgaging the real property. 4. That the act be made to the prejudice of the owner or a third person. Illustration. A sold a parcel of land to B. Later, A sold the same parcel of land to C, representing to the latter that he, A, was the owner thereof. At the time he sold the land to C, A was no longer the owner of the property. Subject is a real property. Par.2. By disposing of real property as free from encumbrance, although such encumbrance be not recorded. Elements. 1. That the thing disposed of be real property. 2. That the offender knew that the real property was encumbered, whether the encumbrance is recorded or not. 3. That there must be express representation by the offender that the real property is free from encumbrance. 4. That the act of disposing of real property be made to the damage of another. Illustration. A mortgaged his property to B. Later, A, misrepresenting that said property is free from encumbrance, mortgaged it again, this time to C. Note, subject is a real property. Par.3. By wrongfully taking by the owner his personal property from its lawful possessor. Elements. 1. That the offender is the owner of personal property. 2. That said personal property is in the lawful possession of another. 3. That the offender wrongfully takes it from its lawful possessor. 4. That prejudice is thereby caused to the possessor or third person. Illustration. The accused pawned his watch to the complainant. Later, pretending to have the money for redeeming the watch, the accused asked the offended party to give him the watch. Once in possession of it, he carried it away without paying the loan for which it was given to the offended party as security. People v. Fajardo. Note, the offender must be the owner of the personal property. Par.4. By executing any fictitious contract to the prejudice of another. The crime of estafa by executing a fictitious contract, of sale, to the prejudice of another may be illustrated in the case of a person who simulates a conveyance of his property to another, for the purpose of defrauding his creditors. The above illustration would be a case of fraudulent insolvency if the conveyance is real and made for a consideration and not simulated, to prejudice a creditor. Par.5. By accepting any compensation for services not rendered or for labor not performed. The crime in this paragraph consists in accepting any compensation given the accused who did not render the service or perform the labor for which payment was made. There must be fraud, otherwise, it becomes payment not owing, known as solutio indebiti. Par.6. By selling, mortgaging or encumbering real property or properties with which the offender guaranteed the fulfillment of his obligation as surety. Elements. 1. That the offender is a surety in a bond given in a criminal or civil action. 2. That he guaranteed the fulfillment of such obligation with his real property or properties. 3. That he sells, mortgages, or in any other manner encumbers said real property. 4. That such sale, mortgage, or encumbrance is, A, without express authority from the court, or, B, made before the cancellation of his bond, or, C, before being relieved from the obligation contracted by him. Illustration. A executed a bond in the sum of P1,000 as one of the sureties for the administrator appointed by the court in the INTE state proceedings of a deceased person. In order to qualify as such surety, A. Exhibited his transfer certificate of title number 9683, covering a parcel of land. Before the cancellation of said bond and without judicial authority, A. sold the land. There was no express finding in the judgment that the sale made by A resulted in any actual damage to the estate of the deceased. Castillo v. People. Article 317. Swindling a minor. Any person who, taking advantage of the inexperience or emotions or feelings of a minor, to his detriment, shall induce him to assume any obligation or to give any release or execute a transfer of any property right in consideration of some loan of money, credit, or other personal property, whether the loan clearly appears in the document or is shown in any other form, shall suffer the penalty of arresto mayor and a fine of a sum ranging from 10 to 50% of the value of the obligation contracted by the minor. Elements. 1. That the offender takes advantage of the inexperience or emotions or feelings of a minor. 2. That he induces such minor, 1. To assume an obligation, or 2. To give release, or 3. To execute a transfer of any property right. 3. That the consideration is 1. Some loan of money, 2. Credit, or 3. Other personal property. 4. That the transaction is to the detriment of such minor. Illustration. The act of causing a minor to sign a receipt for P480 when as a matter of fact the minor received P400 only, coupled with the circumstance that the minor was a fugitive from the house of his parents and was very badly in need of money, was sufficient to constitute estafa under this article. Article 318. Other deceits. The penalty of arresto mayor and a fine of not less than the amount of the damage caused and not more than twice such amount shall be imposed upon any person who shall defraud or damage another by any other deceit not mentioned in the preceding articles of this chapter. Any person who, for profit or gain, shall interpret dreams, make forecasts, tell fortunes, or take advantage of the credulity of the public in any other similar manner, shall suffer the penalty of arresto mayor or a fine not exceeding 40,000 pesos. Illustrations. Fraudulently obtaining a loan on the promise that realty would be mortgaged as security of said loan, which promise was not fulfilled because the borrower sold the property, would constitute estafa. US v. Menzona. Where the accused hired and used a vehicle and then failed to pay the fare, because he had no money, he was guilty of estafa. People v. Santiago. The deceits in this article include false pretenses and fraudulent acts. Chapter 7, Chattel Mortgage. Article 319. Removal, sale, or pledge of mortgaged property. The penalty or arresto mayor or a fine amounting to twice the value of the property shall be imposed upon 1. Any person who shall knowingly remove any personal property mortgaged under the chattel mortgage law to any province or city other than the one in which it was located at the time of the execution of the mortgage, without the written consent of the mortgagee, or his executors, administrators, or assigns. 2. Any mortgager who shall sell or pledge personal property already pledged, or any part thereof, under the terms of the chattel mortgage law, without the consent of the mortgagee, written on the back of the mortgage and noted on the record hereof in the office of the Register of Deeds of the province where such property is located. The chattel mortgage must be valid and subsisting. Elements. 1. That personal property is mortgaged under the chattel mortgage law. 2. That the offender knows that such property is so mortgaged. 3. That he removes such mortgaged personal property to any province or city other than the one in which it was located at the time of the execution of the mortgage. 4. That the removal is permanent. 5. That there is no written consent of the mortgagee or his executors, administrators, or assigns to such removal. Selling or pledging personal property already pledged. Elements. A. That personal property is already pledged under the terms of the chattel mortgage law. B. That the offender, who is the mortgager of such property, sells or pledges the same or any part thereof. C. That there is no consent of the mortgagee written on the back of the mortgage and noted on the record thereof in the office of the Register of Deeds. Damage is not necessary. Chapter 8, Arson and other crimes involving destructions. Article 320. Destructive arson. The penalty of reclusion perpetua to death shall be imposed upon any person who shall burn 1 or more buildings or edifices, consequent to one single act of burning, or as a result of simultaneous burnings, or committed on several or different occasions. 2. Any building of public or private ownership, devoted to the public in general or where people usually gather or congregate for a definite purpose such as, but not limited to official governmental function or business, private transaction, commerce, trade workshop, meetings, and conferences, or merely incidental to a definite purpose such as but not limited to hotels, motels, transient dwellings, public conveyance, or stops or terminals, regardless of whether the offender had knowledge that there are persons in said building or edifice at the time it is set on fire, and regardless also of whether the building is actually inhabited or not. 3. Any train or locomotive, ship or vessel, airship or airplane, devoted to transportation or conveyance, or for public use, entertainment, or leisure. 4. Any building, factory, warehouse installation, and any appurtenances thereto, which are devoted to the service of public utilities. 5. Any building the burning of which is for the purpose of concealing or destroying evidence of another violation of law, or for the purpose of concealing bankruptcy or defrauding creditors or to collect from insurance. Irrespective of the application of the above enumerated qualifying circumstances, the penalty of reclusion perpetua to death shall likewise be imposed when the arson is perpetrated or committed by two or more persons or by a group of persons, regardless of whether their purpose is merely to burn or destroy a building or the burning merely constitutes an overt act in the commission of another violation of law. The penalty of reclusion perpetua to death shall also be imposed upon any person who shall burn 1. Any arsenal, shipyard, storehouse, or military power or fireworks factory, ordnance, storehouse, archives, or general museum of the government. 2. In an inhabited place, any storehouse or factory of inflammable or explosive materials. If as a consequence of the commission of any of the acts penalized under this article, death results, the mandatory penalty of death shall be imposed. Destructive arson v. Simple arson. Destructive arson. Art. 320 of the RPC as amended governs. Characterized as heinous crimes. Grievous, odious, and hateful, wickedness, vicious, atrocity, outrageous and perversity. Penalty is reclusion perpetua to death. Simple arson. PD 1613 governs. Not heinous. Lesser degree of perversity and viciousness, or less significant to social, economic, political, and national security implications. Penalty is not death. Special aggravating circumstances in arson. The penalty in any case of arson shall be imposed in its maximum period. 1. If committed with intent to gain. 2. If committed for the benefit of another. 3. If the offender is motivated by spite or hatred towards the owner or occupant of the property burned. 4. If committed by a syndicate. The offense is committed by a syndicate if it is planned or carried out by a group of three or more persons. Sector 4. Where death results from arson, effect. If by reason of or on the occasion of the arson death results, the penalty of reclusion perpetua to death shall be imposed. Sector 5. TN except if principal intent is to kill murder. Stages of execution, illustration. A person, intending to burn a wooden structure, collects some rags, soaks them in gasoline and places them beside the wooden wall of the building. When he is about to light a match to set fire to the rags, he is discovered by another who chases him away. What crime is committed? B. If that person is able to light or set fire to the rags but the fire was put out before any part of the building was burned, what crime was committed? C. But if before the fire was put out, it had burned a part of the building, what crime was committed? Any charring of the wood of a building, whereby the fiber of the wood is destroyed, is sufficient to consummate arson. It is not necessary that the wood should be ablaze. and the mere fact that a building is scorched or discolored by heat is not sufficient to constitute consummated arson. Setting fire to the contents of a building constitutes the consummated crime of setting fire to a building, even if no part of the building was burned. Chapter 9. Malicious Mischief. Article 327. Who are liable for malicious mischief? Any person who shall deliberately cause the property of another any damage not falling within the terms of the next preceding chapter shall be guilty of malicious mischief. Malicious mischief is the willful damaging of another's property for the sake of damaging it due to hate, revenge or other evil motive. Elements. 1. That the offender deliberately caused damage to the property of another. 2. That such act does not constitute arson or other crimes involving destruction. 3. That the act of damaging another's property be committed merely for the sake of damaging it. Note, this third element presupposes that the offender acted due to hate, revenge or other evil motive. Illustration number 1. Is it malicious mischief if the act of damaging another's property was inspired, not by hatred or by a desire for revenge, but by the mere pleasure of destroying? Yes. Malicious mischief embraces those attempts against another's property inspired sometimes by hatred or a desire for revenge and sometimes by the mere pleasure of destroying it. People v. Sideo. Illustration number 2. A cut small coconut trees on a disputed land to clear it and for the purpose of cultivating that portion of the land. In view of his purpose, A is not liable for malicious mischief. He did not deliberately cause damage to the property of another, since the land is disputed and he believed that the coconut trees belonged to him. Illustration number 3. Also, when the accused chased his opponent who ran to the kitchen of the offended party, and tumbled some tables on his way, thereby breaking various objects, he was not guilty of malicious mischief, because he did not do it with deliberate or only purpose for causing damages. People v. Calantes. If no malice, only civil liability. May a person charged with malicious mischief be found guilty of damage to property through reckless imprudence? Yes. If malice was not proven. Qualifying circumstances in malicious mischief. Article 328. Special cases of malicious mischief. Any person who shall cause damage to obstruct the performance of public functions, or using any poisonous or corrosive substance, or spreading any infection or contagion among cattle, or who cause damage to the property of the National Museum or National Library, or to any archive or registry, waterworks, road, promenade, or any other thing used in common by the public, shall be punished. 1. By prison correctional in its minimum and medium periods, if the value of the damage caused exceeds 200,000 pesos. 2. By arresto mayor, if such value does not exceed the above-mentioned amount but it is over 40,000 pesos, and 3. By arresto menor, in such value does not exceed 40,000 pesos. Article 329. Other mischiefs. The mischiefs not included in the next preceding article shall be punished. 1. By arresto mayor in its medium and maximum periods, if the value of the damage caused exceeds 200,000 pesos. 2. By arresto mayor in its minimum and medium periods, if such value is over 40,000 pesos but does not exceed 200,000 pesos, and 3. By arresto menor or a fine of not less than the value of the damage caused and not more than 40,000 pesos, if the amount involved does not exceed 40,000 pesos or cannot be estimated. Illustrations. A groom who allowed a horse under his care to die of hunger, or a servant who released a bird from the cage, as an act of hate or revenge against its owner. When several persons scattered coconut remnants which contained human excrements on the stairs and floor of the municipal building, including its interior, constitutes malicious mischief. People v. Dumlau. Article 330. Damage and obstruction to means of communication. The penalty of prison correctional in its medium and maximum periods shall be imposed upon any person who shall damage any railway, telegraph, or telephone lines. If the damage shall result in any derailment of cars, collision, or other accident, the penalty of prison mayor shall be imposed, without prejudice to the criminal liability of the offender for the other consequences of his criminal act. For the purpose of the provisions of the article, the electric wires, traction cables, signal system and other things pertaining to railways, shall be deemed to constitute an integral part of a railway system. Damage and obstruction to means of communication is committed by damaging any railway, telegraph, or telephone lines. The crime is qualified, if the damage shall result in any derailment of cars, collision, or other accident. The derailment or the collision of cars should not have been purposely sought by the offender. It must have resulted from damage to railway, telegraph, or telephone lines. Not applicable when the telegraph or telephone lines do not pertain to railways. Article 331. Destroying or damaging statues, public monuments, or paintings. Any person who shall destroy or damage statues or any other useful or ornamental public monument shall suffer the penalty of arresto mayor in its medium period to prison correctional in its minimum period. Any person who shall destroy or damage any useful or ornamental painting of a public nature shall suffer the penalty of arresto menor or a fine not exceeding 40,000 pesos, or both such fine and imprisonment, in the discretion of the court. Chapter 10. Exemption from criminal liability in crimes against property. Article 332. Persons exempt from criminal liability. No criminal, but only civil liability, shall result from the commission of the crime of theft, swindling or malicious mischief committed or caused mutually by the following persons. 1. Spouses, ascendants and descendants, or relatives by affinity in the same line. 2. The widowed spouse with respect to the property which belonged to the deceased spouse before the same shall have passed into the possession of another, and 3. Brothers and sisters and brothers-in-law and sisters-in-law, if living together. The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. Illustration. A was indebted to B in the sum of P100. C, son of B, without the knowledge or consent of the latter, went to A and falsely represented to him that B sent him, C, to collect. Believing the statement of C to be true, A gave P100 to C. The money was not turned over to B, as C spent it for himself. Is Art. 332 applicable? No. The offended party in this case is A, not B. Art. 332 is applicable only when the offender and the offended party are relatives and their relationship is any of those mentioned in said article. Reason. The law recognizes the presumed co-ownership of the property between the offender and the offended party. Stepfather, adopted father, natural children, concubine and paramour are included. Illustration. A stepfather, who was angry with his stepson, took the suitcase of the latter with its contents and burned it in an orchard. What crime is committed? Is he criminally liable? Brother and sisters and brothers-in-law and sisters-in-law must be living together at the time of the commission of any of the crimes of theft, estafa or malicious mischief. Applies only to simple crimes of theft, swindling or malicious mischief and not when any of the said crimes is complexed with other crimes.